Dwayne is supposed to be Zooming. He's in Louisville.
Hello, Rand. How you doing?
Mr. Marshall?
What's up, sir?
Mr. Marshall, I was had to call out the dogs for you.
I kind of close in.
Good parking spot here.
I had a meeting.
Yes, I just looked it up for the other one we did.
Now, normally you're about half hour. Bringing up the rear tonight.
Is there water over there in the kitchen?
Yeah, you get a little cup.
Some in our fridge downstairs.
What do you need? There's a cup in there. Hey, Stace, do you have the resolution we're going to read? I'm sure you sent it to me. But
Which resolution?
Yeah. 2202.
Yeah.
They had it all this year. Well, we left like a minute and a half to go, so we missed that. We'll make it up. We'll miss it back. That was stressful 2 minutes. Like I say, you don't need it.
Dwayne says he's working on getting on.
That's the way I was raised.
So,
I'll keep this up here so we can both see the.
well, we'll count him present when he gets on. All right. Good evening. I'm glad to see everyone here. This is our February 24th regular Scott County Fiscal Court business meeting. Appreciate everybody's attendance. Before we get into our agenda, I want to ask you all to join me or consider joining me in a moment of silence. And I believe it's important, a lot going on our soil and abroad, and a lot of people are hurting and in harm's way. I think it'd be great to just have a moment of silence in respect to that. So if you'd join me, I'd appreciate it greatly. Thank you very much. I'll be praying for peace. With that said, I'd like to ask you to join me in the Pledge of Allegiance. David Livingston, would you lead us tonight?
Yes, sir. You'll pledge with me, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
As we get into our agenda, just to give everybody information that's needed for tonight's agenda, item number 12 is Ordinance 22-01, second reading zone change. We will read the zone change ordinance proposal, and then we will allow for 15 minutes from the applicant and their attorney, and then 15 minutes from the opposition's attorney. Then the court can ask questions and then go from there. I just wanted everyone to know how we would handle that. With that said, I will ask Ms. Hamilton to call the roll.
Mr. Hostetler?
Here.
Mr. Lyons?
Here.
Mr. Wallace?
Here.
Mr. Corman?
Present.
Mr. Ellison?
Here.
Mr. Thompson?
here.
Mr. Livingston?
Here.
Mr. Marshall?
Here.
Judge Covington?
Present. Thank you very much. And number 4 on your agenda is the minutes from our previous meeting. Those were emailed to you, and if there's any questions or comments related to those as presented,
Motion to approve.
we'll have a motion on the floor. We have a second from Mr. Hostetler. Any other questions or comments related to those? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Next, number 5, transfers as presented in your packet. Any questions or comments related to those transfers?
Motion.
Motion from Mr. Rick Hosteller, second from Mr. Tim Thompson. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Number 6, bills and hand checks. Road fund, general fund, road fund from general to 200,000, jail fund from general 300,000. Any questions or comments related to those as presented?
Motion.
Motion from Mr. Livingston, second from Mr. Wallace. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Number 7, let the record reflect that Kelly Corman completed his training unit for 2022. Congratulations. Number 8, clerk fees, January, in the amount of $122,584.90 were submitted on 2/10/22. Let the record reflect that amount. Also, number 9, let the record reflect that sheriff's fees for January in the amount of $23,088.32 were submitted as well. Moving forward as well, number 10, sheriff's fees for December additional and interest in the amount of $157,177.95 were submitted. That leads us to number 11, Resolution 2202, KBI Echo Fiber, and I will turn it over to our friend Jack Connor.
Thank you, Judge, members of Fiscal Court.
Will you pull the mic closer to you?
Let me just do this.
Absolutely.
Is that better? We good?
Yeah.
2 opening comments. Number 1, my name is Jack Connor. I'm not here representing the Chamber of Commerce. I'm representing Scott County United, who is the Economic Industrial Development Group for Georgetown and Scott County. Second comment, we're also responsible for the Junior Leadership Program, which is ongoing right now at 6 o'clock, which is exactly why I'm in the attire that I am. So I apologize for the jeans and not having a coat on. Really pleased to again come before the court with a resolution on behalf of one of our wonderful clients at our Lanes Run Business Park. It's for the final approval for the Kentucky Business Investment Act's incentive, KBI as we call it, for eco-fiber. It's great only because, or a part of because, this is a perfect example of how we can diversify our economy. Certainly not a non-automotive manufacturer. Part of the requirements of the KBI Act itself in terms of this final resolution for KID approval, Kentucky Economic Development Finance Authority, is to have an appearance on behalf of the company. Today, Andrew Lazaro, who is controller for EcoFiber, is here. The responsibility of Andrew is to explain the project, describe the project for you, and then after that, he and I will both be very happy to answer any questions you might have. So, Andrew Lazaro.
Andrew, thanks for being with us.
Oh, well, thank you for having me. And I apologize, our CEO wanted to do this in person, but he's out of the country right now, so you get stuck with the ineloquent accountant. So my apologies in advance. For those of you who are not familiar, EcoFiber is an industrial hemp company that began in Australia and opened operations here in Kentucky after the passage of the 2014 Farm Bill. Our primary operations include our nutraceutical division, which produces a leading pharmacy brand of hemp-derived health and beauty products, and our hemp black operations, which manufactures and sells high-performance sustainable textiles, coatings, and pigments. Initially, we began our operations in a neighboring county. It was a small lease facility, which we quickly outgrew, and we started looking for a permanent location. With Jack's help, we found the property in the Lanes Run Business Park and began construction of our 50,000 square foot facility, which some of you have already been out to visit, and I welcome you all to come out and see it for yourselves and look at what we do. With the initial investment of $15 million, we've created a LEED Platinum certified building, which is only the third of its kind here in the country, and it far exceeds the initial KBI project investment of $5.6 million, primarily because we wanted it to become a showplace for our products and services, as well as a destination for our customers and other partners. We've continued to invest in research and development, and we'll be introducing new products, services, and look forward to a long and prosperous partnership here with the local community. So thank you for your time, and please, I'd be happy to try to help you with any questions you may have.
Any questions?
I was going to ask Jack, well, first of all, Mr. Lazaro, first of all, I did get a chance to go out and tour the site. I appreciate that. I had a somewhat of an idea what you guys did, but I had no idea what you were really doing, and
Sure.
it's a pretty good size production out there. A lot of folks there. It was impressive, I'll tell you that. But I was also going to, so thanks for the tour and the time you took. I was going to ask Jack if he wouldn't mind to talk a little bit about how this investment works.
Sure. Be more.
Sometimes folks think that we're giving out money in advance, and that's really not how, that's actually not at all how it works.
No, sir, and I'll try to be very, very brief. The KBI investment is one, the initial law talks about a but-for clause, and it simply means this: but for the incentive, the company itself would not locate in your community. So the incentive actually is 0.5% occupational tax on a specific set of employment numbers and capital investment. They have met those standards. However, when we went through preliminary approval, of which you did not see, preliminary approval begins with a letter from the CEO of the county, Judge Covington, the CEO, I was the mayor, and the county judge of the city. That then goes to the KITFA board. They approve it. It becomes public. I have before you a process sheet that I prepared if you want to take the time to go through it, but maybe just by me explaining it. So, after the KITFA preliminary approval, they can begin construction, which they have done. As Mr. Lazaro indicated, $5 million all of a sudden ends up $15 million. There is no incentive being paid, taken, or whatever by the company since 2019. This final resolution that you approve is only the next step in the process. They then have to do a final application, at which time then the incentive would be what's called activated. So they would activate the incentive. So since 2019, Scott County Fiscal Court and the City of Georgetown have been generating occupational tax, net profits tax, as well as ad valorem tax on the part of Ecofiber. So without this incentive, this particular company would not be here. It's 50 cents on the dollar. You are not and have not, nor will you lose 50 cents on the dollar. You will, in fact, be getting a significant investment, significant employees, capital investment in the whole thing. Where we are right now is down here. It says local support resolution ordinances public hearing. That's where we are today. The company still has an additional 2 years by which to activate the incentive. So all this time, you're continuing to draw additional revenue from a wonderful company. And I'll repeat what I said earlier. Our strategy is very simple in this community. My strategy is, until our economic development strategic plan is done in March, is to continue to retain and expand our locations. In this particular case, total diversification. We know what our numbers are in automotive, but we also know what we can now do because of the hemp black operation at Ecofiber. Yes, sir.
So along those lines, we're blessed to have the automotive jobs that we have.
Absolutely.
But we're challenged to bring in more diverse opportunities like what Ecofiber presents. And I'm glad to have them in our community, and their facility is top notch, and I think the future is very, very bright for them. So I've been out and toured and just really impressed. So I think that's the type of business that we need to continue to try to draw into our community. So any other questions or comments? At this point, yes, sir.
I was just going to make a motion on that resolution.
Yeah.
Rand will read the
Read it first.
resolution, and then we'll come right back to you.
Can I make one comment?
Absolutely.
Back in September, the Kentucky Magistrates and Commissioners Association actually hosted a fall summit, and Ecofiber
right.
was the host for us, and we had about 130 magistrates and commissioners from all across the state. So they were fantastic hosts and showed everyone the operations, and people walked away very, very impressed
I think Mr.
with our
Wang-
community.
Mr. Wong, Eric Wong was
Yeah,
the
yeah.
CEO, yes, the managing director, excuse me.
Yes.
Any other questions, comments? Rand?
This is Scott County Fiscal Court Resolution 22-02, a resolution approving the granting of local inducements to Kentucky Industrial Hemp, DBA Echo Fiber Kentucky, or any subsequent assignees or approved affiliates thereof pursuant to KRS Chapter 154, Subchapter 32. Whereas the Scott County Fiscal Court finds that it is a legitimate public purpose of said court to undertake activities for the creation of, addition to, or the retention of jobs for residents of this community in the Commonwealth of Kentucky, and whereas the Scott County Fiscal Court authorized the granting of a credit of the occupational license fee in an amount up to 0.5% for up to 10 years for any approved company pursuant to the Kentucky Business Investment, KBI program, and in accordance with the tax incentive agreement between the Kentucky Economic Development Finance Authority and the company, and whereas the Scott County Fiscal Court finds that offering the local inducements authorized by the KBI program for the purpose of creating and retaining jobs is in furtherance of the public purposes of said county and will benefit the Scott County Fiscal Court by preserving sources of tax revenue for the public services provided to the citizens of Scott County. And whereas Kentucky Industrial Hemp, DBA Echo Fiber Kentucky, or any subsequent assignees or approved affiliates thereof, has applied for the benefits authorized by KBI for its manufacturing plant located at 190 Corporate Boulevard, Georgetown, Kentucky. And whereas the Kentucky Economic Development Finance Authority has preliminarily approved the application filed by Kentucky Industrial Hemp, DBA Echo Fiber Kentucky, or any subsequent assignees or approved affiliates thereof, now therefore be it resolved by the Scott County Fiscal Court as follows. Section 1, that the Scott County Fiscal Court does hereby approve the granting inducements to Kentucky Industrial Hemp, DBA Echo Fiber Kentucky, or any subsequent assignees or approved affiliates thereof for a project more particularly described in Resolution Number KBI I-19-22462 as approved by the Kentucky Economic Development Finance Authority on February 28, 2019, pursuant to KRS 154.32-030. Section 2. The Scott County Fiscal Court agrees to forego the collection of 1/2 of the 1% occupational license fee that would otherwise be due it, which shall be retained by Kentucky Industrial Hemp, DBA Echo Fiber Kentucky, or any subsequent assignees or approved affiliates thereof for inducements under the KBI program for a term beginning at final approval and ending no later than 10 years from the date of activation. Section 3, that the Scott County Judge Executive is hereby authorized and directed to execute, acknowledge, and deliver on behalf of the Scott County Fiscal Court any and all papers, instruments, certificates, affidavits, and other documents, and to do and or cause to be done any and all acts and things necessary or proper for the granting of the inducements authorized by the act in this resolution. Section 4, this resolution and the approval contained therein will only impact the eligible company's occupational wages and will not affect the net profits tax imposed by any local taxing authority, including the Scott County Fiscal Court. Section 5, this resolution shall be effective upon its passage and approval. Approved this day, assuming you do 24th day of February 2022.
Any questions or comments? Is there a motion? Motion from Mr. Hostetler, second from Mr. Livingston. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Thank you all.
Very, very much. Thank you.
No, thank you all.
I think Dwayne's still trying to unmute himself.
Perhaps. That will lead us to number 12. As I shared earlier, ordinance 22-01, second reading of zone change request. We'll have Rand read the ordinance, and then we'll go from there with 15 minutes from each party.
This is ordinance number 2022-01, An ordinance changing the zoning classification of certain real property containing a total of approximately 3.44 acres plus or minus, located at 1442 through 1446 Delaplane Road in Scott County, Kentucky, from A1 to B1. Whereas the application of Leaf and Barrel Cigar and Bourbon Lounge, LLC, whose address is 102 Shuttle Drive, Georgetown, Kentucky, 40324, on behalf of property owners Charles and Marcia J. Graves, having been filed with the Georgetown Scott County Planning Commission requesting a zoning classification change of certain real property consisting of approximately 3.44 acres plus or minus, located at or around 1442 through 1446 Delaplane Road in Scott County, Kentucky, and more particularly described in Exhibit A attached here to and incorporated by reference herein from A1 Agriculture to B1 Neighborhood Commercial. And whereas the matter having been heard publicly by the Planning Commission on November 10th, 2021, and December 9th, 2021, pursuant to notice according to law and with a quorum present and voting, and whereas after taking testimony on the application and fully considering same, the Planning Commission voted to make certain findings of fact and to recommend approval of the application to the Scott County Fiscal Court as evidenced by additional documentation provided to the county, including the staff report. Said recommendation sent and received on December 28, 2021. Whereas the Scott County Fiscal Court has considered the evidence presented at the public hearing held by the Planning Commission, together with the recommendations of the Planning Commission and its staff as set out in the records of the Planning Commission. Whereas the Planning Commission has made findings that 1, the proposed map amendment is in agreement with the Scott County Comprehensive Plan, and 2, the planning staff is in agreement. And whereas the Fiscal Court concurs in and adopts the findings of the Planning Commission for the zone change and approves and accepts the recommendations of the Planning Commission as set out in its records, now therefore be it ordained by Scott County, Kentucky, Section 1, that the findings of fact and recommendations of the Planning Commission are hereby adopted and incorporated herein as if fully copied at length. Section 2, that the Georgetown Scott County official zoning map is hereby amended to show a change in the zoning classification for certain real property consisting of approximately 3.44 plus or minus acres located at 1442 through 1446 Delaplane Road in Scott County, Kentucky, and more particularly described in Exhibit A attached here to and incorporated here by reference herein from A1 to B1. Section 3. The Georgetown Scott County Planning Commission is hereby directed to show these zoning classification changes on the official zoning map and to make reference to the number of this ordinance. Section 4. If any portion of this ordinance is for any reason held invalid or unlawful, such portion shall be deemed a separate provision, and such holding shall not affect the validity of the remaining portions of this ordinance. Section 5. All ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Section 6, this ordinance shall be in full force and effect upon passage and publication. Our first reading was February 10th of this year.
With that said, Mr. Cato, give you an opportunity to address the court.
At the end's fine. I think they all have them, but
No, I've shared those, Mr. Cato.
Great. No substitute for papers. Good evening to all of you. Thank you for the opportunity to be here tonight. My name is Zach Cato. I'm an attorney with Billings Law Firm. I represent the applicant in this matter, who's represented tonight by Mr. Larry Ledbetter and Mr. Charles Graves. I hope you don't mind that I'm going to read from prepared remarks tonight to try to keep my time within the 15 minutes I've been allotted and make sure that I don't go over. The Georgetown Scott County Planning Commission publicly reviewed this application twice, on November 10th and December 9th of last year, and ultimately voted unanimously to recommend approval of the zone change. It did so after extensive opportunity for public comment. The applicant respectfully requests that you adopt the record, findings of fact, and unanimous recommendation of the Planning Commission and vote to approve the zone change regarding 1442 and 1446 Delaplane Road. This property is in the vicinity of existing agricultural A1, neighborhood commercial B1, and business research technology park BP1 zones. The Lanes Run Business Park is located kind of diagonally across Cynthiana Road from the property. This area is not purely residential or agricultural. There's kind of a mix of several different zones in the area of this property.
The applicant proposes a small 1,400 square foot cigar and bourbon lounge in the existing structure located at Delaplane Road. The building was originally constructed in 1940 as part of an FFA student project and has been used for many years as storage for the lumber yard that's located on this property, but it's not been used as a residence for a long time. The footprint of that building, which I will call the FFA building, is going to remain unchanged, but will be rehabilitated and brought up to applicable codes and standards if this zone change is approved. The applicant proposes and intends this property to be limited in size and scope, which the small size of that FFA building, 1,400 square feet, will ensure. While the property itself is 3.44 acres, there is no development proposed other than on that 1,400 square foot house. The other structure, which was the Oxford School building, which closed in 1955, will continue its current operation. There's no change proposed to that or the remainder of the property. The remainder of the property will be cleaned up and as part of this process, which has been discussed on the record previously. Future development, if any, of the remainder of that property has to go back through the Planning Commission, where it will be reviewed by planning staff and subject to a public hearing in front of the Planning Commission. In other words, the Planning Commission recommended approval of rezoning this property, but the redevelopment at this time is limited only to that 1,400 square foot building. The application is therefore a very small change from what's in place there today. As far as the zone change before you, the legal standard for a zone change comes from statute. It's Kentucky Chapter 100, Section 213, and the question before you is simple. Is the proposed zone in agreement with the adopted comprehensive plan? The Planning Commission has said yes, and the applicant agrees. Comprehensive plans, according to Kentucky law, are guides. They are not checklists. No applicant has to follow every single detail in a comprehensive plan. In fact, a comprehensive plan in this county is over 250 pages long. It would be virtually impossible to check every single box for every single application that comes before the Planning Commission or before the Fiscal Court. But because the comprehensive plan is a guide, it is not a checklist, that's okay. The Planning Commission's record is replete with discussion of the goals and objectives of the comprehensive plan, which are satisfied by this application. Specifically, preservation and redevelopment of existing structures, Community Forum Objective 3.3, infill and redevelopment of existing structures, which is Housing Objective 2.3 and Environment Objective 2.4, and encouragement of entrepreneurship and a wider range of local goods through small-scale commercial operations. That is Economic Growth Objective 2.2. This all comes directly from the comprehensive plan, which the planning staff agreed this application complies with. In addition, the future land use map, which is part of the comprehensive plan, recommends commercial uses for this property. That's been true since at least the 2006 future land use map. Scott County made the decision long ago that the future of this neighborhood can and should include some commercial uses. The application is consistent with that long-term plan. Further, planning staff noted that the proposed B1 neighborhood commercial zone is the least intensive, least intrusive commercial zoning district in the Georgetown-Scott County zoning ordinance. In other words, the applicant is complying with both the comprehensive plan and the future land use map without seeking a drastic change in the existing use and zoning, as opposed to some of the industrial, manufacturing, drive-through, or other high-intensity commercial uses that may be allowed in other commercial zones, which they have not sought here. The application therefore strikes a perfect balance of the goals and objectives of the comprehensive plan and the future land use map with the characteristics of this neighborhood. The Oxford neighborhood itself is historical in the sense that it's recognized on the National Register of Historic Places. However, that designation does not carry any restriction on zoning, development, or use of the property. In fact, the zoning ordinance in this county has its own historic district category that does impose some limits on historical buildings and historical areas, but neither the Oxford neighborhood nor this property are part of that historic district. In other words, while the neighborhood has been recognized as having some historic character, the designation has no legal bearing on the zoning or the use of this property, which is the question in front of you tonight. The Oxford neighborhood has a long history of mixed residential, agricultural, commercial, and community uses. There have been taverns, markets, filling stations, blacksmith shops, churches, and community centers in the Oxford area dating back to the 18 and 1900s. While there are residential uses in the immediate vicinity of this property, the neighborhood commercial zone, the B1 zone is proposed, and the proposed use properly balance the considerations of the neighborhood, the comprehensive plan, and this applicant. In summary, the application has been thoroughly considered by planning staff, by the Planning Commission. The Commission conducted a thorough public hearing with arguments presented by planning staff, by the applicant, by objectors, by supporters, and they voted unanimously to approve this zone change. Nothing has changed since that vote on December 9th and tonight that would justify overturning their recommendation. The comprehensive plan, including its future land use map component, is in full agreement with the applicant's proposal, and it should be approved. I would like to use the remaining time I've got to address some of the things that I think you're about to hear when the neighborhood has their comments. I want to start by saying that while the applicant and myself don't personally agree with some of the objections that you may be about to hear that have been put in writing and raised to the Planning Commission, we understand why the neighborhood is concerned. This is their neighborhood and they live there. But I would like to point out that this property is very connected to Mr. Graves, whose grandfather started the lumber yard, and he's been part of this neighborhood for years, which has been extensively discussed on the record before the Planning Commission. This is somebody that's been part of this community for many, many years. With that being said, many of the objections made on the record that you're going to hear have already been addressed, weighed, and considered by the Planning Commission before their unanimous vote of approval, but some do warrant additional comment. First, this application is not a request for spot zoning. The undisputed fact is that there are other non-agricultural zones in this immediate area, and the property has been designated for future commercial uses since at least the 2006 land use map. So the idea that this was to always remain agricultural uses is just not supported by the comprehensive plans that have been adopted through the years in Scott County. Secondly, planning staff and the commission have both heard arguments from objectors at the prior hearing that this application somehow expands a non-conforming use of the lumber yard or creates a new one at the FFA building that's not there today. The fact is that the lumber yard predates the zoning ordinance. That's how long it's been there. And no changes or expansion of it are proposed at all. The redevelopment of the 1,400 square foot FFA building, used to be a house, would not be a non-conforming use because if this zone change is approved, it'll be within the zone that's approved. So that would not add a non-conforming use anyway if this is approved. Third, there's no requirement that this property has to be connected to public sewer at this time. You're likely to hear an argument that the zone change will somehow violate the subdivision regulations regarding sewer connections. This is not true for two reasons. First, there's no subdivision or new lot proposed. Planning Director Joe Kane testified, as reflected in the meeting minutes, that the sewer requirement is mandatory only for new lots and does not apply to this as an existing lot. Second, this is a zone change, not a subdivision plat. The technical information which may go into a subdivision plat or even a new construction on a development plan is not part of the zone change consideration. That's not part of what KRS 100 subsection 213 puts in front of the fiscal court as the legislative body. Fourth, you may hear that the neighborhood commercial zone is not the appropriate zone here, but that the L1 light industrial zone or the L2 heavy industrial zone are appropriate for the lumber yard, whereas the B4 community commercial zone is appropriate for the lounge. Whether or not it is possible that another zone could be appropriate here or that another use could be appropriate here is immaterial and irrelevant. The question before the fiscal court tonight is simply whether or not this B1 neighborhood commercial application is appropriate on this property under the comprehensive plan. Furthermore, presumably, the light industrial, heavy industrial, and community commercial zones allow more intense uses than what the B1 allows, and would be even more disruptive to the existing neighborhood than the B1 neighborhood commercial use. For example, light or heavy industrial in this neighborhood would certainly be more disruptive than a neighborhood commercial type use. Fifth, you may hear that the future land use map is contingent upon availability of the public sewer connection. This is also incorrect. If you hear that argument, what you will not hear is any section of the comprehensive plan or zoning ordinance cited to that says designations of future land use is dependent on having utility connections. In fact, every rural area in this county that is rezoned is eventually, one property in every area is going to have to be the first one to move. The first person has to move at some time. If you require that a property can't be rezoned until utilities are already fully connected to it, it ensures that no property can be rezoned until there's extensive resources spent by the county, potentially by the state, by the developer, to a property before you could even try to get a zone change, in hopes that you can get a zone change. That would defeat many of the goals and objectives of the comprehensive plan and severely discourage development that would be otherwise beneficial to Scott County. Fortunately, that's not the law in Kentucky, and it's not required by the comprehensive plan, the zoning ordinance, or the subdivision regulations. Last, you may hear that this zone change is inappropriate because some residents of the Oxford neighborhood intend to participate in the upcoming comp plan update and to have a more detailed plan for the Oxford neighborhood moving forward. That would also include this property. What may happen in the next comprehensive plan, what the neighborhood would like to do, what the community would like to do in the next comprehensive plan is for the next comprehensive plan. It is not in place tonight. It's not part of the consideration for tonight. We already know what the current comprehensive plan says, and it says that this zone change is appropriate. So in closing, I respectfully request on behalf of the applicant that you vote to adopt the record, to adopt the findings of fact, and the recommendation of approval from the Planning Commission. I have paper copies, if necessary, of a motion and findings of fact that I've prepared. Be happy to pass those out and to answer any questions that you all may have on behalf of the applicant. Thank you very much for your time and your consideration.
Thank you. Mr. Grady?
Okay. Okay.
It's the same letter that I sent to you. It also includes pages from the application. It is included my proposed findings.
Okay. Okay. I think they have most of it. Now, they may not have that part of it, so yeah, that's fine. Is any of this
That
new?
was shared in the original record.
Yes.
Yes,
this one.
Yeah, we can take them.
I was just sharing with you that we shared that with them as well.
Hello, Hank.
And just for the record, your motion and your findings of fact, I've shared that with the court, so everybody has copies of that for what it's worth.
Does everybody have a copy?
Can I have one copy?
I think I've got extra there. Yes, ma'am. Thank you.
Again, good evening. Judge Executive Covington, and members of the Scott County Fiscal Court. My name is Hank Grady. I'm an attorney from Versailles, Kentucky. I live in Midway, and I've been asked to represent members of the Oxford community in opposition to this proposed rezoning. I want to, on behalf of the residents of Oxford, some of whom are here and are easily identifiable in Oxford shirts, on their behalf and on my behalf, I want to thank you for giving us an opportunity to make what's called an argument-type hearing, where we don't introduce new evidence, but we argue based upon the evidence that was before the Planning Commission. I also want to thank you for inviting us to put our arguments in writing for the hearing. I did that, as did Mr. Cato last Friday, and I believe you've all received my written letter. I've given you another copy tonight in case you left it at home. We're not going to go through that word for word right now, but what I do want to do is go through what is in the record. So if you look at the three things I've given you, the first is the argument that I would like for you to consider as a basis to reject this proposal. That's in my letter dated February 18th to you. That's the top of the package. The second is the letter that Mr. Cato submitted to the Planning Commission, and it includes the cover page of the application and contents of that letter. And I do want to go through that letter with you. And then finally, the third thing I provided you is a proposed findings of fact and conclusions of law that essentially adopt the reasons for turning this down that are set forth in my letter after we have located areas in the record that I think support our objections, and ask that you conclude as a matter of law that this zone change should be denied. And I would like to now ask you to turn to the second package, which has as the cover page, leaf and it's the application for rezoning in Scott County. And I note in the beginning that it says 1.44 acres, and I note that it says 1442 Delaplane. And one of my concerns is that the action that the Planning Commission has taken appears to be inconsistent with what is actually in the record. We'll get to that in just a minute. If you'll turn to page 2, you'll see the October 25th letter. This letter refers to two properties, 1442 and 1446, and it acknowledges that the property is currently used exclusively for a lumber yard operation. I've highlighted that for you to see that. On the second page, this cover letter from Mr. Cato recognizes that this is a non-conforming use. He includes the definition of, he titles it non-conforming use, and he describes what is allowed in the agricultural zone, and he describes this current use as both a non-conforming use and a non-conforming size. He says, as he did tonight, that this non-conforming use predates the zoning ordinance, and he argues that this actually, his proposal improves things. We believe it does not. He does, in the next paragraph, vicinity of the property, he concedes that the property is currently surrounded primarily by other agricultural zones. If you will turn to the exhibit on my letter, this is the February 18th letter. The first exhibit after my letter is a map of the zones that was part of his application. He locates 1442 Delaplane Road, and this map clearly shows that it is surrounded by agriculture. This is what the map looks like, and it's attached to my letter, and it was part of his application. So his application recognized that he was seeking to locate B1 property in an area that was zoned agriculture and surrounded by agricultural land. That is, by definition, spot zoning. And I mentioned spot zoning in my letter. I cited the case of the landmark case of Louisville versus McDonald, and that case included a quote from an earlier case, 10 years earlier, Fritz versus City of Ashland. And Fritz versus City of Ashland discusses the Supreme Court's criticism of planning and zoning that comes before the court. And that quote is in my letter to you, but I want to call attention to the facts in Fritz. In Fritz, City of Ashland wanted to locate an economic development project that they thought was important, and the economic business was threatening to leave, and they said to the City of Ashland, we need a larger spot. And so Ashland, the City of Ashland, decided to rezone a new location for the business in the middle of a residential area. And it was approved by the City of Ashland. Obviously, they wanted it. On appeal, the Court of Appeals reversed that and found that that was spot zoning. They said the nearest industrial zoning is half a mile away. This is in a residential area, and it is therefore spot zoning. It violates good principles of planning and zoning, and the ordinance approving it was found to be invalid. Now, that was the criticism in Fritz, and the court said, we see a lot of cases where there's spot zoning, and the question is whether they can get away with it because it's a minor violation of good planning principles, or whether it is a major violation of good planning principles. And the court says, what we would like to see is better planning, and planning should precede zoning. And so this issue of spot zoning is a defect in this application. This was ignored by the Planning Commission, and I'm bringing it to your attention because I'm asking you to recognize that this is zoning a piece of property surrounded by agriculture, and that is, by definition, spot zoning. And it is admitted in page 2 of the letter from Mr. Cato to the Planning Commission. So this issue was before the Planning Commission, both in the sentence, this property is currently surrounded primarily by other agriculture, and by the map that he attached to the application that I've just asked you to look at. He then says on the next page, page 3, further, Kentucky's highest court has stated that in the interest of progress, the law favors the gradual elimination of nonconforming uses of property in our cities. It naturally follows that such nonconforming uses are to be tolerated under the law but cannot be enlarged. Mr. Cato cites Franklin Planning and Zoning Commission versus Simpson Lumber Company, and that is the second category of reasons we believe this zone change must be disapproved. That property is today a non-conforming use. All 3.44 acres are a non-conforming use in the agricultural zone. It has one business on it as a non-conforming use. And as a matter of law, when planning and zoning was adopted in this county, that pre-existing use has the right to continue in perpetuity, but it can never be enlarged, it cannot be expanded, and it can be changed in a way that causes it to be expanded. What you have is one non-conforming business use, a lumber yard in an agricultural zone, and it would be a non-conforming business use in a B1 zone. If you grant this request, what you are doing, in effect, is turning one non-conforming business use into two non-conforming business uses, because a cigar bar and bourbon lounge is not a neighborhood business. I have attached to my letter the principal uses in the B1 zone. So if you look below the map that shows that this property is surrounded by agriculture, and then look below the sewage treatment requirement in the subdivision regulations, which I'll get to in just a minute. The next page is your B1 neighborhood commercial. This district is to be used for retail, trade, and personal services enterprises, which will meet regular needs of the occupants of surrounding residential areas. Permitted uses: retail sales for neighborhood consumption, consumer services for neighborhood consumption, professional, business, governmental offices, and laboratories. But I don't need to go into the conditional uses. I did suggest that perhaps B4 might be a more appropriate, although that also appears to be limited to a community. But I've included a B4 designation to enable you to read these two categories and form an opinion about whether B1 is the right zone for a bourbon, a cigar bar, and bourbon lounge. I ask that you find that it is not, and find that as another reason for disapproving the requested zone change. But I also ask you to find that this is turning one business that is a non-conforming use into two businesses that are non-conforming use. It meets the definition of an illegal expansion of a non-conforming use. If you'll turn to page 4 of Mr. Cato's letter, he attempts to move around the fact that these zones don't fit what he's doing by using the words, the proposed B1 is more generally suited to the current uses. The zoning designation is supposed to fit the use, not be close enough. He then says, it is expected to draw its customers from Bourbon, Fayette, and Harrison counties. That is a claim that he is trying to set up in Oxford on Delaplane Road, a regional attraction. And that is not a B1 designation. That belongs somewhere else. He does not request annexation, and my argument in response is under Scott County law and subdivision regulations, he must make that request if he's in the urban services area. If you will now turn back to my letter, Mr. Cato did me the favor of reading most of my grounds for denial, so I won't read them again to you. But clearly they include the concern that this is spot zoning, the belief that this is an illegal expansion of a non-conforming use. Those are points number 2 and 3. And I want to now turn to the attention to the subdivision regulations. 2 minutes? Thank you. Number 4, here and also in the findings of fact, your subdivision regulations, and I attached them to my letter, it says, all development on lots of less than 5 acres shall be connected to a state-regulated and approved sanitary sewer. And then all development within the urban services boundary shall be connected to a public sanitary sewer system, and then it has exceptions that I believe do not apply. This is a mandate that if the property is in your Georgetown urban services boundary, it cannot be developed until it has sewers. Now, that does not mean it can never be developed, but if it is in your urban service boundary, your subdivision regulations and your zoning ordinance indicates that your zoning ordinance is to be applied in coordination with your subdivision regs. So your zoning ordinance and your subdivision regulations mean that this property is not yet ready to be developed. It will be ready to be developed when sewers get to Oxford. And when that happens, then it can comply with this requirement. But there's such a thing as property being premature for development. It's not ready because it doesn't have the services it needs. And that is the correct description of this property. Finally, there is a point that I would like to make. The findings that Mr. Cato read and asked, and they're in the ordinance that is before you, consisted essentially of one finding. It is in agreement with the comprehensive plan. I ask you to find that the land use map, which designates that someday this property may be suitable or will be suitable for commercial, is not yet there yet. We're not there because it doesn't have the urban services. But I also believe that the findings are inadequate, and this application should be turned down because the findings do not meet the requirements of the law. Thank you for the opportunity to speak. I appreciate your consideration of this request to turn it down.
Thank you.
If I could say something before we ask questions, Judge, just to make sure we're all on the same page procedurally. You all have essentially two choices. Obviously, one to affirm what the Planning Commission did and grant the zone change, or you could choose the opposite, not to allow it. Your decision has to be based on the evidence that was produced in front of the Planning Commission. I think all you all have watched those hearings, so you're familiar with that. So we're not taking, obviously, any new evidence tonight. You've got to make findings of fact to support whatever decision you make. If you vote to affirm it, you can certainly adopt the findings of fact that were made by the Planning Commission, or I suppose you can make your own that would lead to you affirming it. If we don't affirm it, you've got to make findings of fact that would support that conclusion. Along those lines, you can adopt what Mr. Grady has submitted, some or all those, or you can advance other reasons that you would find from the evidence that support not granting zone change. So that's kind of where we are. I just want to throw that out there before we ask questions.
David Livingston.
Do we have a third option, though, where we don't have to do anything and their decision goes into effect?
Yeah, 90 days, yeah.
If we did not take any action?
Yes, sir.
Okay.
Questions, comments from the court? David
I'll
Livingston.
start. I don't want to be sitting up here all night waiting for somebody to start. Is it in the urban service boundary?
Yes, it is.
It is. Okay.
Would both attorneys just come to the podium and then you all can address any questions? And if the court members would direct specifically.
I think we both agree that it is in the urban services boundary.
Okay. If this was passed, if the zoning was allowed, the zone change was allowed, the lumberyard is a non-conforming, and so essentially what we would be doing if we went with the 3.44 acres would be making it the entire thing a B1.
That's correct.
And at that point, anything that could fit into that location as a B1 could be used going forward.
I believe if you rezone it to B1, the uses allowed there are in the B1 principal uses.
Okay. Go ahead, I'm sorry.
Sorry, so to that end, if you look in the zoning ordinance and you look for lumberyard, you're not going to find a reference to it.
That's
I looked at it multiple
non-conforming
times.
use.
So a lumberyard can go somewhere. Where does it go? It's already a non-conforming use. It predates the zoning ordinance. There's going to be no change to that part of the property.
But
Actually,
my
two-
question is,
two
I'm
parts.
sorry, let me clarify my question. My question is, I know there is no plan currently for a change to that part of the property, but if it is approved as a B1, could it be changed in the future without coming back to planning and zoning, other than them approving the development plan or come back to us? So we would be changing the lumberyard to a B1 that would allow future development there if requested and approved by planning and zoning.
If it's in the B1, if it's a use that's in the B1 zone.
Correct.
At least go for staff approval for the development.
Okay.
And if it's a rezone, if they're going to try to change the zoning again, it goes through this entire process.
Okay. There's something that you said, you talked about development zone changes that you can't require utilities to be run or sewer before you make the zone change because it would be cost prohibitive and never happen. But you could make it subject to sewer being run before the zone change and the development is allowed. For example, Toyota. I'm sure that they wanted sewer and everything else and everything that could be put out there before they allowed the zone change and came to an agreement on that. and that's not a question, that's just a statement. Why annex? Why required to be annexed? That's probably a question for Matt.
The applicant doesn't want it to be annexed.
Well, but that's not what that's, I don't think that's what it said in here. I think it actually said, I saw something about, I'm not going to go digging back through, but it doesn't matter. But that's one of the subject twos is to be annexed when, at the appropriate time. So why is that one of the requirements to be annexed?
Matt, would you answer, please?
We would, I guess in most cases, we would require annexation when property is rezoned to an urban land use. We would consider all of our commercial zoning districts to be in an urban land use. There are a variety of reasons for that in as far as good planning practice. In this instance, there is not property that is adjoining it that is inside city limits.
Next question.
So that is part of the reason why annexation would not be or could not be done at this time.
Okay.
Mr. Livingston, anything else?
Can I hold questions for further? And allow
Absolutely.
somebody else to?
You're not limited. Any other questions, comments from anyone on the court?
If I
I'll
can-
make, go ahead. Okay. In regards to the spot zoning, and I know we've got different opinions, but from when I drive out there to the site and I look around and we've got all this agricultural area and then we've got 3.5 acres that we want to change into a different zone. And I think as leaders in the county, we have to look and say, is that what we want in the county? To go and make zone changes in little areas that aren't already in the city and don't have the support of city sewer and water and the things that go along with that. So to me, that is a concern. I think it is spot zoning. And I guess you guys can debate, if that's what this is or not. But if you drive out there and look, you get that feel. There's no other businesses. It's all farmlands when you look around. On this issue of public sewer, and I attended both of the meetings for the commission on the hearings on this. When it was asked about the 5 acres and public sewer, the commission's attorney, and I quote, said this is a serious issue. I also quote, he says, our rules are 5 acres or sewer, end of quote. And he quoted, the rule is pretty clear, end of quote. My research, I think it is pretty clear too. I think it needs to be on 5 acres. I think it puts us in a position in the future that we have to make exceptions when people come to this body and say, we've only got a half an acre or we got an acre, but you've approved it for someone else. I think that rule is there for a reason. And then the last comment I have is this B1 zone. And I agree that when we look at the retail sales for neighborhood consumption, consumer services for neighborhood consumption, professional, business, government offices, I don't see a bar in that. And it's not just neighborhood consumption as in their own application. Or I guess when they talk to the commission, they're hoping to draw from other counties. So those are three comments that I have.
Tim Thompson.
That was actually the last comment that Mr. Corman made was the comment that I was going to make. Why B1? I know you said it was the least intrusive and least intensive, but just as far as the permitted uses, how do you figure it fits into that category?
For the applicant?
Yes, sir. I'm
He
sorry.
uses the word neighborhood, which I think is a little bit maybe confusing, but it's neighborhood scale. Neighborhood scale. This is a 1,400 square foot redevelopment of an existing building that used to be a house. So it is neighborhood scale in the sense that we're not building a big standalone restaurant. There's no drive-through. There's nothing like that. It is on the neighborhood scale. The second thing I would say is that the third thing that's on that list is offices, government offices. I mean, that's not neighborhood either, but if it's a small office, it could be in the neighborhood scale, which is why it's permitted in the B1 neighborhood commercial zone. So the scale of the operation and the use is, I think, what's relevant, and that does fit here. That's why we picked B1.
Well, I guess the follow-up with that is the neighborhood consumption. I get what you're saying. Same way with the Dollar General in front of Bradford. It's for that particular area. It's the way that I would see something here in Georgetown. I guess the question that I have is, if it's for that particular vicinity of folks, why did you put in the other part about trying to draw from other counties?
So I'll ask you that I drafted that letter. That came from me. And so that letter was done as part of the initial application, and this has been addressed on the record as well. What I will say is that if I overstated the case of the client, I apologize, but I think it was made very clear at the Planning Commission hearing that this is intended to be a small operation. That's why they don't want to expand the building. It is what it is today. So yeah, there's going to be cigar smokers that are come from Fayette County. They're going to drive up from Fayette County, or they're going to drive from somewhere else because there's nothing like this close by. That doesn't mean there's going to be 50 cars in the parking lot, or there's going to be 100 people milling around outside the business. So when I say it's bringing in people from around the area, that's what I'm talking about, the market for this. Not that it's going to have people coming and going all day like a Dollar General store or a pharmacy or something. So I may have misstated the case, and if I did, I hope you don't take that out on the applicant, because that was my words, and I may have not put that artfully enough.
All right, thank you, sir.
Mr. Livingston?
No, that answered my question.
Down, anyone else down this way? Mr. Marshall?
Mr. Cady, as I look at the application, Mr. Grady pointed out that it says, and I realize this might have been amended, and I guess that's my ultimate question, that it's for 1442 Delaplane Road, and the size of the tract is 1.44 acres. Did that change at some time, or can you flesh that out?
So what happened is when the application was filed, there was a survey in process, but it wasn't complete. There are actually two parcels that have never been formally subdivided. One is 1442, one is 1446. One's 2 acres, the other is 1.44. I don't remember which is which, but it's never been formally subdivided. There's no plat. So we got the survey results back and figured out that the lot lines did not land where we thought they did, and that the fix for that was either to stop what we were doing, go do a subdivision plat to change the lot lines, or to change the application to just rezone the entire property. However, the scope of what's been proposed has never changed. It's always just been this smaller building. And secondly, all the notices that went out, the sign that was posted, all that was at the property all along. So it was amended and updated prior to either one of those hearings. So that's just an outdated application, basically.
Okay. Thank you.
May I respond? I'm looking at the minutes of in December when this was voted unanimously to approve, and it says rezone the property at 1442 Delaplane. Does not mention 1446. So in my mind, there is confusion about what has been rezoned. And I added that complaint as part of my reasons for turning this rezoning application down. That was the last point in my list of objections.
Maybe Matt can speak to it.
I don't think that the Planning Commission had any doubts about the property or the size of the property. They are aware that both addresses exist on that property at the time that they had the hearing. We could have easily referred to it by either address. Both addresses would be applicable to that property.
But it's for both tracks together. Is that accurate, Matt?
Yes. Yeah. I mean, in my mind, it is just a single tract, as Mr. Cato pointed out. It was never subdivided, so it is just a single tract that has two addresses.
Intent of law doesn't make it law. You can say intent all day. They intended to make it 1442-46, but they didn't. The minutes don't read that way. So what would be important to do is to go back and look at the actual footage to see what was actually voted on. Because if we go by the minutes and we go by the original application, because that's all we have in front of us tonight that was provided to us, 1446 is not mentioned. So the minutes, you can say, well, it was intended, but it's two different addresses.
But this, I mean, the staff report refers to the correct acreage. There were maps
That's not what they
provided.
vote.
There were
It's
there
a
were maps
problem because
provided
it's
at the
not
meeting.
what they voted on. We've had to go back and fix votes before because it was worded incorrectly. And when you vote on it, that is the decision. It's not, oh, well, they meant to do this. And that's not our problem.
The point's noted.
Yeah.
Thank you. Rick Costello.
Those guys really on the other end have brought up some of my concerns or thoughts, but I'll add two on the sewer connection. Actually, it's going to be, if it goes down as they voted, it will be a septic system. That's what's intended. That has to be approved and all that. So since we're taking in the whole property, although I understand Mr. Livingston's concerns and somewhat agree, but if we're considering the whole property, are you going to tie the existing business into that septic system? Is that a requirement? Should you? I don't know. Just
There's currently no service at the, you talking about the Oxford School, the
yes,
school building?
the existing business.
There's currently no service there. There's not going to be any change to it. And the septic is going to have to be brought up to code and approved by the health department before it could ever be used for anything.
Is there a septic already there?
Mm-hmm. There is on the FFA building. Yes.
Okay.
Any other questions?
If there's no questions, I'll make a motion. If no one else has further discussion, I would make a motion that we do not accept the zone change, and I would refer to Mr. Grady's explanation and as what we need to, how do we?
Yeah, I don't want to put words in your mouth,
Sure.
Kelly, but yeah, I want to make sure we're on the same page. You're saying deny the zone change. Are you adopting the findings of fact in whole or in part? If it's in part, obviously, I need to know which ones you are and which ones you aren't,
Right.
that were submitted by Mr. Grady.
I would do it in whole.
Okay. Does everybody have that? It's entitled Findings of Fact. It's 1 through 13. I just want to make sure everybody knows what Kelly's referring to. Obviously, if you're going to vote either way, you need to know what he's suggesting. Everybody on the same page there?
Yes, sir.
Okay.
Just a second to look at it.
Yes, absolutely. There's a request for time to review. We'll do that.
Judge, I had a question.
Question from Mr. Wallace.
Mr. Grady, can you come up here? Can you further explain what you mean by on your findings of fact for number 12?
Yes. As I said in my letter to you, words to this effect, that where there was testimony before the Planning Commission from Brad Green, one of my clients, that the residents of Oxford intend to be active participants in the current 2022 Comprehensive Plan Update to develop a more detailed plan for the community of Oxford. The non-conforming use of the lumberyard, including the FFA building, should be addressed as part of the entire community of Oxford. That is, in response to being asked to consider what I have called, and what some of you may believe is spot zoning of one particular, or now maybe two lots, 3 acres in the larger community. The future of the lumberyard and the future of the FFA building should be part of a community process that is part of the comprehensive plan, and it should be done with the entire community, including the graves. And that is the right way to plan the future of this property. It also addresses the issue of a comprehensive plan map that designated a large swath of area as commercial without addressing the issue of sewers. So your comprehensive plan does need to be fixed as it relates to Oxford, and this finding number 12 references Brad Green's testimony to the Planning Commission. So this is not something I came up with. He is in the minutes that he brought this before the Planning Commission. I'm asking this fiscal court to recognize that part of the record in this case and support it by turning this down and essentially sending this property owner back into the community to work with the community on a plan for the entire community, including this property.
Right, I understand, and this is no reflection on Mr. Green or the comments, but I guess it more has to do with something that has to happen in the future versus something that is reflected on reasons of why there needs to be a denial.
Clearly, I can acknowledge to all of you, I'm stating to you, I believe that this landowner has come into the zoning process too early, and he should be turned down because this property is not ready for the services he needs to operate that kind of business. But more than that, I think the comprehensive plan needs to be re-examined to have a better future for this community. So this is a request to turn down and postpone changing the land use for this 3.4 acres now and get it back in step with a good planning process that the community wants to go through. So I am asking for delay. I mean, I'm not hiding that. I'm saying it's not ready.
Okay, I understand, thank you.
We have a motion.
And I tell you what, if I can read it, and then if it's not right, you tell me, Kelly. The findings of fact submitted by counsel for the Oxford community, Mr. Hank Grady, numbers 1 through 13 are adopted in whole, and accordingly, the zone change from A1 to B1 is hereby denied.
Yes. Do we have a motion?
What did you say?
I said we have a motion.
Oh, okay.
Is there a
Asking
second?
for a motion. I'll second.
We have a second. Are there any other questions or comments?
I have a question. Rand, is the first and second, is the motion, period, for 1 through 12? Would all that be part of it?
Well, I've got 1 through 13. Is there one on the next page, hopefully?
Yeah, there is, our copy.
Oh, I'm missing that. Okay, 1 through 13?
Yes, ma'am.
All of it?
Yeah. You're going to do a roll call.
We're going to do a roll call. So we have a motion, we have a second. And Ms. Hamilton, will you call the roll?
Judge, before we do that, you want to just clarify how this yay or nay?
Yeah, get ready to ask that. So if you vote yes, you're voting for the motion, and the motion is to deny the zone change.
Mr. Hostetler?
Yes.
Mr. Lyons?
Yes.
Mr. Wallace?
Yes.
Mr. Corman?
Yes.
Mr. Thompson?
Yes.
Mr. Livingston?
Yes.
Judge Covington?
Mr. Ellison, you skipped Mr. Ellison.
Oh, I'm sorry.
Mr.
Can
Ellison.
you hear me?
Yes.
Your vote?
Yes.
Your vote
My vote is yes.
All right.
Thank you.
My vote's yes. that said, that concludes that matter before the court. Thank everyone for their time and consideration. We will move forward with number 13, EMS new hire.
Good evening, Judge, Magistrates.
Chris Runyon, how are you today?
I'm doing well, thanks. How about yourself?
Tough act to follow.
I would just like to present for the court's consideration a full-time paramedic hire with our department.
Hey, Chris,
We
can't hear you.
just a second, buddy.
Sure.
All right, Mr. Runyon.
Mr. Jeff Coulter, he brings 20-plus years' experience to our department as a EMT and paramedic.
Can you share his name again? I'm sorry.
Mike,
Will you shut the door?
Shut the door.
Thank you, Mike.
Thanks.
Would they do that at a
Sorry.
No, you're fine. It's Jeff Coulter, Coulter. 20-plus years' experience in EMS. We'd like to hire him as a full-time paramedic effective March 14th at a rate of $17.70 an hour.
Where'd he come from?
He's currently in Nicholas County,
Okay.
and but he's worked several places around the state. Got a pretty wide variety. Been in fire and EMS and administration as well. Some experience there. He's an educator, which helps us. So.
Is there more than one or just one?
Just one tonight.
Okay.
Yeah.
Motion.
Second.
So we got a motion down here, and I heard a second, and I saw Alvin's hand.
I might have more. Wait. That was too easy.
who's second?
Tim Thompson. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Just real quick, I'm going to beat Rick to the question. Where's that put us?
That leaves us one vacant.
One vacant.
Now, we still have a couple off on injury, but we have one vacancy. And we'll interview.
Please, JR.
One
One vacant.
One paramedic or
EMT, one EMT, yeah. And we'll conduct those interviews next week.
Right.
Along those lines of staffing, I feel like it's okay to share. Chris and I have been meeting, and we've met now for 3 different times with BCTC's staff in regards to a collaboration on a paramedic certification program that we would work together on. And very optimistic that we're going to get this done. We'll bring more information to you as it comes to us, but I'm very hopeful.
Yeah, that last meeting was exciting. I feel like.
Yeah. Thank you, Chris.
Thank you.
Hey, Judge,
Yes.
well, what, and maybe we do this under new business or something, but Chris sent out an email earlier this week.
House Bill 505.
Yeah.
Can we
Can
come
we
back
talk?
to new business and talk about
That'd be
it?
fine. Thank you.
Yes, sir. We'll move to number 14, Code Enforcement Board Appointment, Joint Alternate. Mr. Thompson.
You got the wrong motion.
No, EMA.
EMA hired. Oh. You can come back, Mr. Thompson. EMA new hire. Mike, how are you?
I'm doing well. How are you guys?
Good.
I'm requesting approval to hire Laura Hoffman as a part-time per diem employee for EMA. She doesn't come with 20 years' experience. She's going to be one of my 2 new people that we bring along. She's shown a great interest in emergency management, wants to go through the process and become an asset to our community. She'd be coming in at $12.61 an hour, which is the same as all the rest of our employees. We've been approved for a total of 10 employees. This would bring us to 8. So,
Any questions or comments?
Motion to approve.
Motion from Mr. Alvin Lyons. I saw a second from Rick Hosteller, I believe. Is that correct?
Yes, sir.
Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Now, Mr. Thompson, when we go to this Code Enforcement Board Appointment Joint Alternate, A joint alternate serves only when one of the appointees cannot be in attendance for hearing.
Before we get started, Rand, do I need to recuse myself?
For what reason?
Because they're replacing my mother.
No, I don't think, 'cause, I mean, regardless, she's not returning or even eligible to return, is that right?
I believe so.
Okay, no, I think you're fine.
Okay, can I vote twice to get voter off the board?
We'll gladly vote you off the aisle.
Oh, okay.
Are you going to get voted off the aisle?
Individual that is willing to serve in this role, we all are very familiar with, Jane Lucas. Any questions or comments?
Motion.
Motion from Rick Hostetler, second from Kelly Corman. Any other comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. We'll move to number 16.
Tim.
And call Sheriff Hampton. And JR's calling Tim back in.
It is 5 degrees in here.
Sheriff Hampton,
I turned it up.
thank you for being with us.
Yes, sir. Good evening, Judge.
JR, would you ask our gentleman to put up the PowerPoint? He's on it.
I know.
Sheriff Hampton came and met with myself and discussed needs for vehicle fleet, kind of a pre-budget conversation. And the reason for the pre-budget timing is simply this: the supply chain concerns, and if you don't get at the front of the line, you might not have options until extremely late in the next budget year. Sheriff Hampton, would you add anything to that else?
You're absolutely correct on that part.
So
It's hard to get fleet right now across this dealership.
will you turn that around there, Sheriff?
This
Thank
program,
you.
okay.
Yeah. So I'll turn it over to you. We appreciate you being here. And Sheriff Hampton then met with Alvin, David, and myself and discussed the proposal. And after doing that, we felt like it was appropriate to bring it to the full court for your all's consideration.
How do you change this slide?
You say next.
All right, so.
It's magic like that.
All right, I like that. Great. So to start with, we met with Enterprise, Judge Covington and I, and JR, and Lieutenant Cottle, who's my fleet guy. We met with Enterprise, and their program is really a lease program. You lease the vehicles, and you turn them in 3 years or whatever lease term you agree to. The other issue with Enterprise, too, was they could not get the Tahoes and maybe could get the Explorers and or Chargers, which we're obviously going away from. So contacted Bachman. That's who we've been buying from for the past 3 years, the Tahoes. And he said, well, we have a lease plan, a lease purchase plan, but actually you own the vehicles at the end of the lease. You can do a 3, 4, or 5 year lease. But at the end of the lease, whichever you choose, you own them. The county owns the vehicles. So Lieutenant Cottle has put this together for me. Let's go next. So can you put all those up? Okay, so current fleet cost and offsets for fiscal year 21. 50% of our office fleet have over 100,000 miles. We have a total of 53 vehicles utilized daily for community and public service. In 2021, cost rose to $233,000 from the general budget for maintenance. Sworn personnel on an average 18 to 22,000 miles of patrol-based vehicle per year. They put that many miles per year on. High annual miles per year will continue to increase yearly maintenance costs, especially in the vehicles with over 100,000 miles. Yeah, you can go ahead and put all those up. Upfit cost for the sworn vehicles: light, siren, prisoner transport, divider, radar, mobile data terminal, push bar, vehicle ready, radio, etc. L&W The 2021 upfit cost was $18,500. The estimate for this year is going to be $22,500 for the same equipment on these vehicles. And L&W is under state contract, and they're the only people I know of in Kentucky that does this. I think Joe Monroe with UKPD is the chief there. He sends his vehicles out of state to be upfitted, but then you're looking at how you're going to get them worked on if something goes wrong with it. So L&W is who essentially everybody in Kentucky uses. The cost of a 2022 Chevrolet Tahoe is $41,622.62, and 2023 should be the same according to our representative. So add the upfit cost to make the total price for one Tahoe $64,122.62. At this price, 5 Tahoes, which is what we bought last year, cost the Scott County Fiscal Court $320,613.10. The lease program on Kentucky State Contract has a proposal of the following. The 2022 Chevrolet Tahoe Police Package with upfit, 10 Chevrolet Tahoe vehicles with upfit at a price of $214,110.79 per year on a 3-year lease. That's for all 10 vehicles. After the 3-year period, the total cost of the 10 vehicles would be $642,332.37. That Scott County Fiscal Court has paid and would actually own all the vehicles at the end of this lease term. Benefits of this lease program: lower overall cost of maintenance. Currently, we spend an estimated cost of approximately $233,000 on vehicle maintenance alone. With newer vehicles comes fuel efficiency, maintenance costs per vehicle, and overall safer patrol vehicles on the roadway for our deputies. The cost equivalent for the current ownership of 5 vehicles would be greater than the actual cost of leasing a total of 10 vehicles at a time. So Scott County Fiscal Court purchases 5 Tahoes with upfits, $320, $613.10 in 2021. Scott County Fiscal Court leases 10 Tahoes with upfit for the year 2022 at $214,110.79, a difference of $106,502.31 in a year. The Scott County Fiscal Court purchased 5 fully outfitted Chevrolet Tahoes for the Scott County Sheriff's Office this past fiscal year at the price of $320,613.10, or the Scott County Fiscal Court can lease, if chose, 10 fully outfitted Chevrolet Tahoes for the Scott County Sheriff's Office this year and provide 10 more reliable vehicles at a savings of $106,502.31. In 2022 through 2025, a 3-year lease term, the agency would have 10 vehicles less than 4 years old, under leased warranty, and could add that to eliminating every vehicle within this time frame from the fleet with outrageous maintenance costs and high mileage over 75,000 miles. In closing, we're not going to save in thousands of dollars in the purchase of vehicles, but we are going to lower the cost of the maintenance over a long term, and we would get 10 vehicles up front. We will need more vehicles every year after that, but maybe only 4, 5, 6. But we've discussed doing 10 and 10. I know it says on here 4, 5, or 6 are not 10. We can execute the lease, but don't have to pay until after the new budget starts. We don't have to purchase as many vehicles every year, but only the amount we need based on each year after we take a look at where we're at after we get our fleet built back up. So you all have in front of you, did you all get the lease agreement?
Mm-hmm.
Okay.
Email.
So what y'all have in front of you, there's one sheet that's got some highlight on it. So the ones that are highlighted, except for what's circled, so 1, 2, 3, 4, 5, we would propose to sell those. And you can look at the mileage on all those and see that they're substantial. And then you have another page where JR and I have talked. JR has a need for pickup trucks. So we would propose passing on a 2015 Dodge Ram and a 2020 Dodge Ram to JR in the road department. We would propose to sell 3 Explorers, 2 of them 2014 and 1 2017, and then sell a 2015 Charger. You'll see on their pool cars, we need to keep 5 pool cars in the fleet, at least 5, because sometimes if we are having maintenance done, JR, they have to send it out, and it takes a little bit longer. So 5's a good number to keep us comfortable to have in case we wreck one or whatever. So with that said, this lease is for 3 years, payment of $214,110.79 a year, and we own the vehicles at the end of that.
I've got a question. Yeah. And you may have said this, but what's the warranty on the vehicle? How many does it get a mileage? Like 100,000?
It's got a powertrain of 100,000, wasn't it, Alvin?
That's what, yeah.
So, and I didn't really get a chance to review this real well, but I'm looking at this one sheet that says it's financed at $616,000 with an effective interest rate of 4.3 or 4.298, whatever. I mean, it's about $24,000 a year in interest that we pay, and that's it's not a huge amount of money, but I think in the past we've bought vehicles.
Yes,
not leased
we've
them.
always paid for them.
So I didn't know why exactly we're trying to make that change because it seems like I understand it if it's a warranty issue, but it sounds like they would still be under warranty even if we just paid for the vehicle, right?
And that would actually be up to you all, either way. This is just a way to get more vehicles at one time and keep the cost down per year. I know there is a little interest, but the other thing to think of too is I think after next year, these vehicles he's projecting they're going to go up $2,000 to $3,000. So you've got that. You've got upfit costs, which I read to you what that went up in a year. And who knows now what's going to be available. This is the big thing, the availability, and these vehicles are available now, as opposed to there's a lot of law enforcement agencies out there that don't have them from when they ordered them last year.
But Kelly, your main question is, traditionally we have purchased vehicles, and now the proposal is a consideration of a lease. And what are the merits of the lease that would outweigh just buying 10?
And I guess what he's telling me is we could maybe get 10 units soon, and instead of doing two, or whatever, we might spread them out, I guess.
Right. And we bought 5. I think we went 6, 5, 5 over the last 3 years.
That sounds right.
And
there's no cash discount.
I'm sorry?
No cash discount that you're aware of?
No, this is state contract, and honestly, I believe these are as cheap as the Explorers, and everybody likes them better. They're more roomy. Since we've been buying them in 2018, they've been very dependable. And I don't know, JR, have we had any major maintenance issues? Now, I can tell you the Dodge Chargers, I'm just going to tell you, we put many, many engines in those. And the other thing, too, I might as well go ahead and tell you, we lost one during the flooding the other night. Deputy got too far in trying to get to somebody, so I'll be getting that up to you so we can turn that into insurance. And also, we had a Tahoe that was T-boned over the weekend, and we don't know where that's at.
But the thought process, your thought process is if we elect to replace 10 in lieu of 5, that the significant savings could be on maintenance.
Absolutely. That's, I guess, JR.
Well, so traditionally, we've bought them outright. Traditionally, we bought them outright, as we've already said. But that, when you buy them outright, you're not going to get 100,000-mile powertrain.
No, I believe you would.
Yeah, no, it's that's what they come with. No matter how you.
3 years or 100,000, whichever comes first. Is that right?
Yeah,
that's right. Is that Chevrolet or is that Dan Cummins?
No,
Is that where it's coming from?
Bachman.
Bachman. Is that? But I mean, is the warranty through the dealer or through the
So we would be able
brand?
to take them to Dan Cummins.
Okay.
We did check on that.
But I didn't know. Yeah, but is it a Chevrolet warranty or is it a dealership warranty? Okay.
Tim or Chad?
Yeah, Tim was first.
Okay. Thank you, Chad. The biggest issue, or I'm sorry, we do this with the city of Georgetown, and I'm a fan of the lease program. So I think what Sheriff Hampton is talking about is valid points. Typically, before we were doing the lease program, when you buy a vehicle outright, you may keep that vehicle for a really long time. So then by the time that you try to turn around and sell it, you're not going to get much for it. And then, like you talked about, as far as just the cost of maintenance, we've seen a drastic drop in maintenance as far as for the city, as far as the fleet. You get a 3-year turnaround for emergency vehicles, correct? Is what it is, 5-year for non-emergency, what they talk about?
We've been keeping.
Well, no, I think he's talking about within the lease.
For the lease program, it's what they suggest.
Yeah, I mean.
So you come out ahead.
So, I mean, we could try to trade these after 3 years. And I'll give you an example. The Franklin County Sheriff's Office took one in, a 2018 Tahoe with 56,000 miles. And Bachman was giving him $35,000 for it. That's how good the resale is on these things. It's just the state contract price, you just can't.
Yeah, you come out ahead, I feel like. Yeah.
And then I guess we'd have to look at that, how they're performing at 3 years, how many miles they have on them. Should we trade them or should we run them for 6 years?
Chad, and then David.
I'm going to identify this car by the number because it might be an undercover car. I'm not exactly sure, so I don't want to.
Oh, you're fine.
It's a SO14. It just kind of stuck out to me why we're not looking at putting it into one that we roll out.
So, honestly, it's a good car, and it's one of our bailiffs that has it. And I think JR and I found that used with very low miles on it at the time. We've had it for a while. Did we buy it from Paul Miller or Fayette County Sheriff? Fayette County Sheriff. Yeah. So, I mean, it's something that I would entertain taking out and switching with something else. We need to put it in a museum.
It just kind of stuck out to me.
Yeah.
And I thought,
nobody has Crown
It's not undercover.
Yeah, well.
So, correct, it's an 05 Crown Vic.
I do.
It's still humming.
Yeah. And Barney fight the auction because he wants to go for it.
That's the rest of the story. Any other questions or comments?
8-track. I was going to talk about what Kelly mentioned, and I guess it's one of those things where if you think about it, if you wanted to get 10 this year, you're going to have to spend $616,000, $635,000, whatever that number is, or you spend a little interest over the 3 years. It's simple interest, it looks like, and so to spread your money out over the 3 years. And so I guess it just depends on, do you want one lump sum or do you want to spread it over? Because I would assume in this.
Over 3 years.
Yeah, I mean, I assume you could actually not have to finance it and pay it up front.
We could take him a check for 10 for 600 and whatever that was.
16,000.
Yeah.
But the X factor is the maintenance.
Right.
The decrease in the maintenance.
But if you buy 10, you're still going to have the savings of the lesser maintenance.
That's right.
Yeah.
I think Sheriff Hampton was just trying to present another option that would not require
so much up front
as a significant capital investment.
Sure.
But and then the reason we're talking about this now is just because the supply chain, and you need to be at the front of the line or we'll be at the back of the line. And I'll be honest with you, we've sent out memos requesting that budgets be submitted by what day, Stacy?
15th.
The 15th of next month. I feel confident that we'll get them before then. We're not reinventing the wheel. But if the court wants to entertain, the investment of 10 on a purchase instead of a lease, that's certainly something that the court could consider. I think the sheriff was just trying to present an option that had a price tag that was lower, but still allowed us to realize the savings on the maintenance.
If we did,
Alvin?
if we did the purchase, that would hit in this budget year also. The lease payments would not hit till next budget year, is that?
Well, the 214,000 initial lease payment, if we don't pay the first lease payment until the cars or the vehicles are delivered.
Right. Actually, he said we wouldn't have to pay anything until after they went to L&W and they were ready to hit the road. L&W is telling me on some parts we're 2-3 months out. Just on
That was what I was
parts.
going to ask you next. The vehicles are available, or is L&W able to get their stuff?
He's going to be able to get some of them done, but not all of them right away. But at least we would have the vehicle.
There's no way that this will come due before July 1.
No, there's not a way. But
Is that your question, Al?
Yeah, well, if we purchase or lease either one, it would be pushed back in.
Yeah.
I guess what I would be asking for permission to do tonight is to move forward and get these vehicles held and start getting them upfitted as soon as we can, but no monies would be due until the new budget year, for sure.
And I guess we just need to figure out, do we want to do the 3-year payment or
outright purchase?
lump sum? Yeah.
The significance of getting older vehicles off the road and having the potential of savings on maintenance is a very big positive to me. J.R. Brandenburg and I have talked quite a bit about this. J.R., do you want to share anything?
We kind of looked at some rough numbers. You'd almost have to do the first year, but we kind of figured $20,000 to $25,000 a year of savings in maintenance. So
There's your wash on your interest, really.
Your oil changes, your tire rotations, new tires, that's all still through our staff.
Judge, I think I'm in favor of moving forward with this program. I think if we do what we were calling the lease and what the sheriff's recommending is, it gives us some options, because in 3 years from now, we might be in a different financial situation. It gives us options if we want to continue with the program or not. If we purchase them straight out, we now own them, and we'll be stuck with them. And that's going to give us some options long term, in 3 years from now at least.
Yeah, but if we enter into this agreement, we're committed to 215,000. I'll call it 215 for 3 years, and at the conclusion of that term, we own those vehicles.
Right.
And it is my belief that we will need. We'll need to consider more another order next year, because if we don't, we're just playing.
And that's why I gave you all this list,
issue.
so you all can look at the mileage. And also, there's some on the back too, if you didn't see it.
I think the goal is to try to get the fleet as many cars down that's below 100,000 miles as possible on the road. I think it's a goal.
Well, and Mr. Thompson, I think you'll agree with me that they don't recommend emergency vehicles being driven, past 100,000 miles. They like you to try to.
That's what we actually utilize Enterprise, and that's what they try to do, a 3-year rotation on emergency vehicles, because they're so, the stop and go, the high speed, everything. So I think if we entertain this and go forward with this, I think it just makes sense. I know we'll use this now as, I guess, kind of like just, trial right now, but I think that we're going to enjoy it enough to where we'll probably continue to do it, because you're going to have new vehicles on the road, less maintenance, and I really like the program.
Rick Hostetler.
And somebody's already said it, but it's simple interest, so if we decide 2 years from now, we can.
That's true.
We can pay off and save that 3rd year's interest.
Is there any
I'm just saying
early payoff penalty?
No, I believe it's.
I didn't
on
see
here,
anything in there, but
I'm sure Chuck told me that it's not.
so it just gives us options, like everybody already said.
We could be here next year and we could say, okay, we're going to elect to go ahead and pay the balance of the next 2 years at one time, and then order X more, whatever.
Yeah.
There's what Chad said, what you're saying is there's flexibility.
The reason I'm continuing to chew on it is my parents said if you want something and you don't have it in the money in your pocket, you don't get it. So, but anyhow, a little old school. Sorry.
I think lease has changed too over the years. I think it was a dirty word there for a long time, but I think programs have really changed.
Judge, I'll go ahead and make a motion to move forward with the program that Sheriff Hampton has presented.
Lease purchase option of
Yes,
10
Yeah.
Chevy Tahoe.
We're going to go against my parents' advice tonight.
We have a motion and we have a second.
First time.
Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes.
Appreciate y'all. Thank you.
Well, thank you. Next, we will, I'd like you to consider, and I'd like you to consider approving Scott County Fiscal Court's participation in the regional broadband RFP that I shared with you all via email. This includes Woodford, Clark County, Madison County, Bourbon County, Jessamine County, and Lexington and Fayette County. The language in the RFP clearly states, and I shared, that we have already entered into an agreement with Spectrum, and that our court will not commit any more capital funds. The plus of entering into this RFP is if Charter Spectrum wins this RFP, the possibility of significant savings for our project exists because of it's just economies of scale in all the projects. And just think about going down a county road and you end here, and on the other side's Bourbon County or Fayette, and there's 10 houses there. The benefit is they don't have to stop at the county line. They can gather in those 10 houses, and it's just the economy of scale. This is non-binding, allows for flexibility to pursue either a regional multi-county solution. RFP contracts or agreements will be subject to approval by individual local governing bodies. It's a turnkey solution. I'm not going to read all those points, but this is only a win for us. If there's no commitment capital-wise, and if Charter Spectrum wins this RFP, there could be a significant savings for us. And that it'll be a competitive bidding process, and I'll entertain any questions that might come.
If Spectrum wins it, it doesn't change our timetable, does it?
We are first in line.
Okay.
And just to give you an update, I talked with Jason Keller today. They're very optimistic about, hanging fiber and moving forward before the end of this quarter. They're moving their engineering process and planning is where they want to be. He said he anticipates 2 or 3, teams working when they start the process, and then you'll have other teams come in behind that do the installation and such. So, this is what they do. And on the NTIA grant, I'm still very optimistic we'll get good news. Hopefully within, what I was told was a March 1st target. You never know when you might get good news. I think the federal government likes to share things on Fridays.
Depends on what it is.
Yeah. If you want to kill it, share it on Friday.
Just to remind you, we applied for $3.1 million. That is our commitment to the broadband project. If NTIA awards us that $3.1 million, those federal grant monies will take the place of our commitment, and we'll have $3.1 million that we can spend on other needed projects in our community, or whatever the court decides to. It'd be a great thing. So, is there a motion to approve participation in the regional broadband RFP as described?
No brainer.
Motion. Oh,
go ahead.
Motion and second by David. Any other questions? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. We're at new business. I think Rick wanted to talk about new business with,
Chris, and that House bill that you had question on, did you get any feedback, or I'm just wondering where that was at?
Yeah, so it's House Bill 505, and it's kind of a revision of House Bill 296, which initially went a few weeks ago, and it's being pushed by the Kentucky Hospital Association, and it kind of is a hostile takeover of EMS in the state. So rather than, it would pull EMS out of where it is now, kind of under education, under KCTC, the K-Beams board is, and we'll put it under the Cabinet of Health, but it would give the Hospital Association control of EMS in the state from training, scope of practice. Like, I mean, it's pretty, I don't have the information here with me, but I don't really want to get down that rabbit hole today, but it's I would call it a hostile takeover.
Was that in committee? Did it come out of it?
I don't think it's come out of committee.
Yeah, so, right, no, it has not.
But it's, and it has to do with call priority and,
yeah.
I mean, there's so many bad things in this bill. And so I was telling Chris before the meeting that we had the executive committee meeting at CAECO today, and I brought it up, and they said that, you know, you get sometimes over here with a bill in Frankfurt, it's just kind of smoldering and nothing ever happens and it just goes away. And then in the last week, this one has caught fire. Yeah. And everybody's talking about it. And it's just the hospital association that's pushing it. Right. Nobody else is. None of the other associations to do with government, you know, county government, city governments support it.
so I forwarded to Philip Pratt our opposition to it. Chris added to that email.
I did. Yeah, and it boils down to the non-emergency transport trick. The hospital is not happy with not being able to get their folks moved out and free up beds. So it's kind of a hospital problem that they're blaming on EMS. And some counties have that problem, right? They do. Their EMS is not, doesn't serve the hospitals well and handle those non-emergency transports. But it's not. This is just a blanket. Rather than addressing those particular areas, this is a blanket kind of, we'll just take over EMS. But I was on a conference call this afternoon just shortly before I came up with the EMS Association, and there are some proposed, so they finally got the Hospital Association folks to come to the table and said, hey, let's kind of get a compromise here. We'll give a little bit if you'll give a little bit. They're going to try to propose some legislation, I think, this session, but they want somebody other than EMS to sponsor that, so they're looking at CAECO or KLC to push that through. And
David, can you assist there?
Yeah, it addresses their concern. Their primary concerns would be taken care of under this. It would allow them some options to deal with those transfers, but it wouldn't be. You know, we would kind of EMS would stay where it is, and we would still have a lot of say in our training and our scope of practice and that thing. So that's the latest.
Any other questions? Any other new business?
Yeah. At our next workshop, would it be possible to get planning and zoning up here to talk about the issue that Assistant Chief Canavy brought up at our last workshop, and specifically with the sizing of lines, of water lines and fire hydrants in newly developed subdivisions out in the county? And I like to look at that, and if that's something that we need to start moving forward with to address some of those issues, then that's what we need to look at doing.
I will request them to come and share and have dialogue.
Thank you.
Any other court member with any new business? Joe Broyles has, Joe Broyles, how are you?
Doing well, sir. How are you doing?
All right.
Good evening, Judge. Good evening, magistrates. Just had a few quick items for you. While we're thinking about vehicles, I'll probably be approaching the sheriff to see if we could transfer one of those Explorers over to the jail. We've mothballed a couple vehicles this year that were in need of mothballing, and so I'm probably going to approach him to see if we could get one of those Explorers from him. I'd also like to publicly thank Georgetown City Council and GPD. They actually transferred a vehicle to us, an Explorer, here in the last few months. So I want to thank them. It's a perfect fit for us. We do transports, but most of them are usually within 60 miles to the jail, so we don't usually go that far, so we don't need a brand-new vehicle most of the time. So that was one thing. The second thing I had was we had a incident at the jail this week. One of my deputies got hurt. He's going to end up having to have surgery, and he's going to be off of work for 6 months. So if you can kind of keep him, without mentioning any names, in your prayers, that would be great. My SOPs, which you guys need to approve, are going to be gotten to you here in about a week. I can include it with or without things that have been changed to make it easy on you, or I can just provide the whole document. There's numerous things throughout. Some of them are cleanup things. Some of them are changing of a couple of words in a section. Some of them are completely new sections. So it's not a complete revision, but it's pretty close with stuff throughout the entire SOPs, and it's been kind of a major project to get it done. When we revised them initially back in 2015, it took a year to revise them, so it's taken close to that this time. So I'll get those to you guys here in the next week or so. And then my final thing for you guys is just want to bring it to your attention, we're 50% overcrowded today. So it just, between that and the COVID protocols, which eat up any additional space that we have at the jail, we are really tight. So.
Any other questions for Judge Board?
Well, I'm just wondering while you're here about, so you're still not having any of the state prisoners out?
No, sir. No, I promise you, if I could, I would. But we do not have the space. The inmates that go out on the work crews into the community, they have to be segregated away from general population inmates. Last week, we were housing inmates in hallways, quite honestly. So we absolutely don't have space right now to carve out a cell just for a work crew. So if that changes, I'll let you guys know, but I don't anticipate that changing anytime soon. What would change, what would help with that, because certainly, as you guys know, we've been more overcrowded than we are right now. We had 127 inmates earlier today. I think we're down to 121 right now. A few years ago, we were 130 or 40. So we've been more overcrowded, but what's eating up the little bit of extra space that we have is the COVID protocols and the quarantining of new arrests that come in, the quarantining of them until we get the COVID test back on them.
And whose are those protocols? Just wondering.
Those are my protocols.
To do the isolation and?
Yes, yes. And that's obviously in an effort to try to keep COVID to the best of our ability. And there's many more protocols that go along with it. That's just one of them. But that's just an effort to try to keep COVID out of the facility as much as we can, because we're in such an enclosed, tight environment down there.
At one point, you and I had a conversation, and I asked you if you had proposed capping the population of the detention center at one point or not, at a point where you felt safety was a concern, primary concern. What number would you put that at right now?
I'll tell you what my number is, and it's about 140 is where I'm saying, hey, we can't take any more. Now, a few years ago, we got up to in the 160s. I don't want to get back to that situation. Obviously, the safety and security of the facility, the more you pack people in there, the more that gets compromised. And so when we reached into the 160s and got back down, I talked to my captains. I said, let's not do this again. So 140, 145 is about as much as I feel comfortable putting in there. And even that's too much, obviously. 140, 145, you're talking 70%, 75% overcrowded.
But if there was a number, and if, we looked at other options, obviously the first other option would be consideration of other local detention centers that were nearby that we could have an agreement with.
Which we actually do every month anyway.
Yeah.
We have 5 to 15, depending on what our numbers are down here at the jail and the needs of the jail. Some of those that are housed in other counties are inmates that we can't have around inmates that we already have in the county. So we've got 3 female cells. If we've got a female that doesn't get along with people in each one of those cells, then we've got to either keep her in isolation, which you can't do that forever, or we got to house her somewhere else. So we're currently housing, I think, 6 in other counties.
And Judge Deals in Grant County, I've talked to him about, the prospect. I've never spoken with Judge Williams. I would like to
Where's
investigate.
Judge Williams?
Judge Williams, Bourbon County.
Okay.
I was just thinking about nearby facilities.
Yeah, if you want to put me on the spot, I'll give you input. But we're currently housing not in either of those facilities.
Okay. I'm just looking at, are there other alternatives that are nearby?
Right.
We have to pay X dollars per day in our facility. It costs X. If we house them at a facility nearby at another, they charge X dollars. We already pay that on a regular basis. My question to the court, to you, is, should we consider some type of agreement with other facilities that once we get to a point that we automatically communicate to law enforcement that, we're going to ask you to transport to a different facility.
Right. Well, and I already do that. So I've already got jails that I utilize based on my experience with the jails and knowing how they operate. And obviously, I try to make them as close as possible for the sheriff's office convenience and not make them.
What would be the most efficient way? Would our law enforcement, whether it be GPD, Scott County Sheriff's Office, state police, regardless of number in our jail, would they still, bring that arrestee to your facility? We'd process them and then try to transport them from there, not even put them in a permanent placement.
Yeah, when we shut our jail down a couple of years ago, they were transporting them directly to the facility.
So they wouldn't even bring them to our detention center at that point.
Correct.
Just take them directly to whatever facility we had
Right.
that agreement with.
Yeah, the problem is then getting the paperwork from that facility to our circuit clerks, which could be worked out, but, there's inevitably things are going to get lost in the translation.
We're not going to answer all these tonight.
Just one quick question, Darren. Of your 120 inmates you got in the detention center right now, how many of them are state inmates?
Probably about 30.
So then if you got rid of those 30, then you would be about 105% of capacity?
If I could get rid of those 30, yes.
But they're there because they're pending charges.
Well, yeah,
Is that correct?
most of them are pending charges. Few of them have been convicted. The state is supposed to remove them within 90 days, but they don't.
Okay. That's all needed.
Yes,
And
sir.
there's a bill in regarding state inmates and getting them processed faster and getting them out.
It's in Bill 31.
There's a House bill too. Michael Meredith has it.
Yeah.
There was actually a lawsuit filed by an inmate in northern Kentucky because he had been in a county facility for over a year after he had been convicted and waiting for classification to be transferred out.
Because state prisons are nicer.
Yeah, because, right.
Well,
Yeah,
You
so-
you don't have any part in that process, right or wrong?
No, that's the state that does that. Yeah, I have nothing.
What-
I will tell you, though, you mentioned housing in other counties, and we could do more of that, but I try to balance it because other counties, they're going to charge more than what we can house them for in Scott County, and the convenience and the cost of the sheriff's office. So,
Respect that. Thoughts and prayers for the staff member.
yeah, thank you.
No doubt. Thank you. Any other new business? Anyone here in our audience? J.R. Brandenburg. J.R., would you share with the court, because you are our point man on this great, good news, and I think it's very big that we do this. I appreciate you.
Yes, sir. Good evening, everybody. We
we've been contracting with Swartz Mowing to pick up trash last couple of years, and been working with him, and he give us a date of starting Monday countywide, mixture of all roads, and he's going to hit it Monday.
About 200 miles, correct? City and
Yes.
county.
Yeah,
And-
everything mixed together,
And we
state,
have a
city, county.
collaborative effort between our road department and Public Works. There'll be hundreds of bags.
Yes.
On the side of the road, and we will pick those up.
Probably 1,200.
1,200 bags.
Roughly.
So I would entertain here soon the discussion of the city. I've talked with the mayor and with the Public Works folks. He wants to designate a couple of those that are just assigned to litter abatement. I still think we ought to have a couple new staff members added to JR's staff that are assigned to the same task out in the county. And then those two teams work collaboratively a few days a month on roads that need traffic control and roads that are a little bit more, a challenge to pick up trash. West Main Street is an example. I'm sure they're everywhere.
Yeah,
But that would be something I would like to talk about at our work session and see if we can move forward with something like that as well soon. It's 9:10. If there's no other new business, is there a?
Thank you.
Thanks, JR. Is there a motion to adjourn? I see Kelly and a second by David Livingston. All those in favor? Any opposed? We are adjourned.
Get out of here.
But it felt good, didn't it? Hey, Stace.